Ever found yourself wading through, a really dense legal document, trying to pick out the bits that actually matter?
Happens all the time. They're not exactly light reading, are they?
Definitely not. Well, today we're tackling a big one, the UK's Building Safety Act 2022. We're digging into the core government sources here.
Yeah, and our mission really is to cut through all that legal jargon.
Exactly. We want to unpack what this act really does.
Understand the new rules, the new players.
And what it means for you, whether you're living in a building, you own one, or you work in the construction industry.
We're aiming to pull out those crucial nuggets, those aha moments.
Okay, let's get into it then. Let's unpack this. So maybe the first question is, why? Why this act? What was the real driver behind it?
Well, it wasn't just dreamt up, was it? It's a direct response, fundamentally, to the need to improve safety. Safety for people in buildings, around buildings,
Right.
and also just generally to improve the standard of buildings being built and managed.
So it's about creating a framework.
A clear framework, yeah. Proportionate, ideally, for designing, building, and crucially, managing safer, better quality homes. The idea is owners manage buildings better, and the industry itself has the structure it needs to deliver, well, frankly, better homes, higher quality, safer homes. It's a real shift in approach.
A big shift like that usually means new structures, new organizations coming into play.
Absolutely. The Act sets up a whole new regulatory landscape, 3 main bodies, actually.
Okay, who are they?
First, you've got the Building Safety Regulator, the BSR, and what's quite telling is that this role is given to the Health and Safety Executive, the HSE.
Ah, interesting. So leveraging their existing expertise.
Exactly. It signals that shift, doesn't it? From just checking compliance after the fact to a more proactive, risk-based safety culture. The HSE knows safety.
Yeah, the BSR's main goals.
Pretty clear, really. Secure people's safety in and around buildings, regarding building risks, and improve building standards overall, especially for these higher-risk buildings.
Okay, that term keeps coming up. Higher risk building. What does the Act mean by that?
For certain key parts of the Act, it generally means a building that's at least 11 meters high or has at least 5 stories.
So taller buildings, apartment blocks, that sort of thing.
That's the main focus, yes. But it's worth remembering that regulations can tweak this definition. They could even include temporary structures, vehicles, vessels. It's adaptable.
Right. And the other 2 bodies.
You also have the National Regulator of Construction Products focusing on the materials themselves.
Makes sense.
And the new Homes Ombudsman for dealing with issues with new builds.
Okay, and another definition that seems vital is building safety risk. What falls under that umbrella?
It's defined quite broadly, actually. It's a risk to the safety of people, again, in or about a building that arises from the spread of fire or structural failure.
The big ones.
The big ones, yeah, but also crucially, or any other prescribed matter.
Ah, so leaves room to add other things later if needed.
Precisely. It's designed to be comprehensive, not just limited to the most obvious hazards right now. Catches those potential systemic risks.
So we have the new regulators, the key definitions. Now, who is actually responsible on the ground? The Act creates new roles, doesn't it?
It does, and this is absolutely critical for accountability. 2 main roles here. First, the accountable person.
Okay, who's that likely to be?
Think about, say, an apartment block again. The accountable person could be the freeholder, or maybe the management company. It's the person or entity that holds the legal estate in possession of the common parts. The hallways, stairs, lifts, maybe the structure itself, or has the main repairing obligation for those parts.
Right, the day-to-day responsibility for the shared bits.
Essentially, yes. Now, what if a building has multiple accountable persons? Maybe different parts are owned or managed differently.
Yeah, that happens.
That's where the principal accountable person comes in. If there's only one accountable person, they're also the principal. But if there are several,
Who takes the lead?
the principal is the one who holds the legal estate in the structure and the exterior, or has the primary repairing duty for those core parts. They have the ultimate oversight for the whole building's safety. The buck really stops with them.
And if there's confusion about who is who?
The first-tier tribunal can make a determination. There's a mechanism to resolve disputes about who holds these crucial roles.
Okay, so the roles are defined. Let's get into the meat of it. What do these accountable persons actually have to do? What are their core duties?
Right, the to-do list.
Right.
First and foremost, it's about assessing and managing risk.
Proactively.
Absolutely proactively. For occupied higher-risk buildings, the accountable person must assess the building's safety risks for their part of the building. And not just once.
Regularly.
As soon as reasonably practical, and then at regular intervals. They have to take all reasonable steps to prevent those risks or reduce them if they can't be fully prevented.
So ongoing vigilance.
Ongoing vigilance, and importantly, making arrangements for effective planning, organization, control, monitoring, and review of those steps.
Yeah.
It's about having a proper system in place.
And they need to document this. Prove they're doing it.
Yes, that leads straight to the safety case report. This is a key requirement for the principal accountable person.
What goes in that report?
It has to contain those risk assessments we just talked about and a description of the steps they've taken to manage those risks. It's basically their argument for why the building is safe.
A living document.
It has to be. It needs to be revised whenever necessary if things change, if new risks emerge, and they have to notify the BSR about it and provide copies if asked.
And just generally keeping records. That's a duty too.
A big one. Accountable persons have to keep specific prescribed information and documents, copies too. They need to be kept up to date and follow prescribed standards.
What if they don't actually have the information? Say, historical records.
They have a duty to try and obtain it unless it's genuinely impracticable to do so. The aim is a complete picture.
Okay, so lots of duties on the owners and managers. What about the residents? Do they get a say in any of this?
Yes, definitely. The Act puts a real emphasis on resident engagement. Accountable persons for occupied higher-risk buildings must prepare and maintain a strategy specifically for engaging residents and owners on building safety matters.
So consulting them, keeping them informed.
Both. And it goes further. The BSR itself has a duty to set up and maintain a residence panel.
A panel of residents.
Yes, to give advice on how the BSR carries out its functions relating to these higher-risk buildings. And there are specific provisions to ensure disabled residents are included and consulted too.
That's important. And if residents have specific complaints about safety?
Accountable persons need to set up and run their own system for investigating relevant complaints. These are complaints about building safety risks or about whether the accountable person is fulfilling their duties.
So an internal complaints process first.
Yes, but importantly, the BSR also operates its own complaints procedure. So residents have another route if they're not satisfied or if it's a broader issue.
It sounds like transparency and information access for residents is a really major theme running through this.
It absolutely is. Regulations can require accountable persons to give specific information or documents not just to the BSR, but directly to residents and owners too.
Can residents just ask for information?
Yes, residents age 16 or over, or owners of units, can request prescribed information or documents from the accountable person.
And they have to provide it.
They have to provide it as soon as reasonably practicable, and often in an accessible format. This duty generally overrides confidentiality agreements unless it clashes with data protection law. It's about empowering residents with knowledge about their own homes.
Makes sense. Now, for accountable persons to do all this, check things, manage risks they might need to get into individual flats or areas, how does access work?
They can request access to premises. They need to give proper notice at least 48 hours and request it for a reasonable time.
And only for specific reasons.
Strictly to perform their duties under the Act. Or maybe to check if a resident has contravened their own safety duties.
What if a resident refuses access?
Well, the accountable person can't just force their way in. They'd need to apply to the county court for an order granting access. So there's a proper legal process. So moving on to how all this is enforced, because duties are one thing, making sure they're done is another, the Act has real teeth here.
Okay, how does it ensure compliance?
Well, the starting point is registration. The principal accountable person for an occupied higher-risk building commits a criminal offense if that building is occupied but isn't registered with the BSR. Full stop.
So registration is mandatory.
Absolutely. And beyond that, when the BSR directs them to, they have to apply for a building assessment certificate. This is basically the BSR assessing their safety case report and deciding if the building meets the required safety standards.
So the BSR isn't just a register keeper, they actively assess.
They do, and they have significant powers to investigate if they suspect something is wrong.
What kind of powers? Like inspections?
Yes. They can authorize officers who can enter premises, non-domestic premises like common areas or offices, often without a warrant. Domestic premises, like individual flats, require a warrant.
And once inside?
They can take measurements, photos, samples of materials. They can seize evidence if they think an offense has been committed and need to preserve that evidence. And they can demand specific information or documents relevant to their investigation. It's quite comprehensive.
And what happens if people don't cooperate or try to mislead the BSR?
That's an offense in itself. Providing false or misleading information to the BSR is taken very seriously.
Okay.
Also, for the professionals involved, the registered building inspectors, the building control approvers acting outside the scope of their registration, or even just pretending to be registered when they're not, those are also offenses, potentially leading to fines or even prison.
So deterring bad practice right across the board. What about forcing action if something is wrong?
The BSR has a range of notices it can issue. A compliance notice requires someone to fix a contravention within a set time.
Like sort this problem out.
Exactly. If the situation is more serious, presenting an imminent danger, they can issue an urgent action notice. And they can even issue a stop notice to halt specific work if it's unsafe.
And ignoring these notices.
That's another offense. Of course, there are rights to appeal these notices to a court or tribunal, so there's oversight.
Does liability stop with the company? What about the individuals running it?
Good question. The Act includes provisions for the liability of officers. So if a company commits an offense, and it happened with the consent or connivance of a director, manager, or similar officer, or was due to their neglect,
They could be prosecuted too.
they can be held personally liable, yes.
Yeah.
It pushes accountability right up the chain. And then there's perhaps the most significant intervention tool, the special measures regime.
Typical measures, what does that involve?
This is for situations where an accountable person is seriously failing in their duties, perhaps repeatedly, putting residents at risk. The first-tier tribunal can step in and appoint a special measures manager.
Who takes over?
Effectively, yes. This manager takes over all the building safety functions of the failing accountable person. They can manage the building's finances related to safety, handle contracts, collect service charges for safety measures, even bring or defend legal claims.
Wow, that's a major step.
It's a very significant intervention, designed as a last resort to ensure resident safety when the normal system of accountability breaks down completely.
Right, okay. So we've talked duties, enforcement, let's talk money. Because remediation, managing buildings properly, it all costs money. Who pays?
The million-dollar question, sometimes literally. Well, firstly, the BSR itself can charge fees for doing its job, registrations, assessments, that sort of thing. That seems fair enough.
Sure. But the big one is remediation costs, especially historic ones.
Exactly. And here, the Act provides some really crucial protections, particularly for leaseholders. Essentially, the Act says that certain service charge amounts related to fixing relevant defects in relevant buildings are simply not payable by tenants who have qualifying leases.
Not payable at all.
Not payable, yes, but there are conditions. This protection applies if the landlord or someone associated with the landlord was actually responsible for the defect in the first place.
Okay, so if the developer or landlord caused the problem.
They can't just pass the buck onto leaseholders via service charges for fixing it. Also, there are protections based on the value of the lease at a specific point in time, the qualifying time. If the lease was below certain value thresholds, then the leaseholder is protected from these costs.
That sounds like a huge deal for many leaseholders trapped with unsafe buildings.
It's potentially life-changing for some, yes. Shifting that financial burden is a core aim.
But we need to be clear on relevant defect. What exactly qualifies?
Right, it's specific. A relevant defect is one that causes a building safety risk, specifically relating to fire spread or structural failure. And crucially, it must arise from relevant works. So the original construction or conversion or even subsequent remediation work that was completed in the 30-year period before this section of the Act came into force.
30 years. Wow. So work done decades ago could be covered.
That's right. If a building was finished, say, 28 years ago, and a fire safety defect linked to that original work is found now, it could potentially fall under this definition. That 30-year look-back is a very significant aspect of the Act's protections.
Okay, so protections are there, but how do you actually get the remediation work done or recover costs from those responsible? What are the mechanisms?
Several powerful tools. Firstly, remediation orders.
Who can apply for those?
Interested parties, that could be the BSR, the local council, the fire service, or importantly, anyone with a legal or equitable interest in the building, which could include leaseholders or resident groups, they apply to the first-tier tribunal.
And the tribunal can order.
They can order a relevant landlord, the party responsible, to actually carry out the work to remedy specified defects by a certain deadline. It's a way to force the repairs.
Okay, what else?
Then you have building liability orders. These are granted by the High Court.
What do they do?
They tackle the issue of complex company structures. If a company responsible for defects might be trying to avoid liability, maybe by dissolving or having no assets, the High Court can make an order extending that liability to an associated company, like a parent company, or another company in the same group if it's just inequitable to do so.
Piercing the corporate veil, essentially.
That's the idea, yes. Preventing companies from hiding behind complex structures to evade responsibility.
Clever. Any other orders?
Yes. Costs contribution orders. These relate specifically to failures involving construction products.
Okay.
If a building or home is made unfit for habitation because a construction product didn't comply with requirements, or there was a misleading statement about it, or the product itself was inherently defective, a court, or even the Secretary of State, can order the party at fault, the defaulter, to pay towards the costs of fixing the resulting problems.
So, targeting the product manufacturers or suppliers, too.
Potentially, yes. Whoever is deemed the defaulter in relation to that product failure.
And you mentioned the time limits for these actions earlier, particularly for construction products.
That's right. And it's worth restating because it's so significant. For new product failures going forward, the limitation period for bringing an action under the Act is 15 years from when the right of action accrued.
Okay, 15 years.
But for past failures, specifically related to cladding products, the Act retrospectively extends the limitation period to 30 years.
30 years for past cladding issues. That really does open the door for seeking redress for historical problems.
It's a massive extension, yes, acknowledging the long-term nature of these issues. Okay, so we've covered owners, residents, finance. What about the professionals involved in designing and building? The architects, engineers, inspectors.
Yeah, how does the Act affect them? Does it raise the bar for competence?
It certainly aims to. Building regulations made under the Act can now impose specific competence requirements on appointed persons. Think site managers, principal designers, principal contractors, and other key people involved in building work.
What does competence mean here? Just qualifications?
It's broader than that. It covers the necessary skills, knowledge, experience, and behaviors needed to fulfill their roles properly and safely. It's about ensuring people not only know what to do, but act appropriately.
And the building control profession itself, the inspectors. Big changes there too, right?
Huge changes. The old system of approved inspectors is effectively replaced. Functions are transferred to new roles. Registered building control approvers, often companies or organizations, and registered building inspectors, individuals.
And they're subject to stricter rules.
Much stricter. Both categories are subject to professional conduct rules and operational standards rules set by the BSR. There are mechanisms for investigating breaches and imposing sanctions, warnings, fines, suspension, even striking them off the register entirely.
So, proper professional regulation.
Exactly. And as we touched on earlier, it's now an offense for them to act outside the scope of their registration or pretend to be registered. Plus, local authority building control departments must now use registered building inspectors for certain restricted activities and get their advice on restricted functions. It embeds registered, regulated professionals throughout the system.
Okay, turning to the consumer side again, someone buying a new home, what's new for them?
Two key things here. Firstly, the new Homes Ombudsman scheme.
An independent body for complaints.
Precisely. An independent person to investigate complaints against developers who are members of the scheme. Membership is expected to be mandatory for most developers.
And they'll have standards developers need to meet.
Yes, the scheme will maintain a public register of members, and there'll likely be a code of practice covering developer conduct and the quality of their work. It gives home buyers a clear route for redress if things aren't right.
Okay, and the second thing?
Mandatory new build home warranties. Developers are now required to provide one for new build homes and their common parts.
Like the existing NHBC warranty or something different.
The Act sets the framework. It has to be an arrangement where the developer agrees to fix specified defects within a set period, and critically, it must be backed by an insurance policy. So if the developer goes bust or refuses to fix things, the insurance should cover it. It provides that safety net.
That sounds like a solid protection. And what about the actual stuff buildings are made of, the construction products?
Addressed directly, the Act establishes the National Regulator of Construction Products.
Overseeing the materials market.
Yes. Regulations can impose requirements on anyone involved with construction products, manufacturers, importers, distributors. This covers things like declarations of performance, ensuring products do what they say they do, proper marking.
CE marking, UKCA marking, that kind of thing.
Exactly. But also monitoring product performance after they're on the market, and crucially, having systems to notify authorities if risks are identified. There are specific, stricter provisions for products deemed safety critical.
So trying to stop dangerous products getting into buildings in the first place?
That's the core aim, yes. A much tighter regulatory grip on the products themselves. Now, for this whole complex system to work, the BSR, local authorities, product regulators, ombudsmen, they all need to work together, don't they?
Absolutely. Silos would undermine the whole thing.
Right. So the Act explicitly requires cooperation. The BSR must cooperate with local authorities, fire and rescue services, and the various ombudsmen, including the regulator of social housing, when exercising their relevant functions.
And sharing information.
Information sharing is also specifically authorized between these bodies and even with the police, where it's necessary for their functions. The only major caveat is data protection legislation. They can share info unless it breaches GDPR, essentially.
So breaking down barriers to ensure safety information flows where it needs to.
That's the intention, connecting the dots across the different organizations involved.
And technology plays a part in this, making information more accessible.
Yes, there's a definite push towards digital systems. The BSR is required to set up and maintain an electronic facility, basically, a digital platform for giving and receiving relevant information.
A central hub.
Sort of, yes. And they also have to keep an electronic register of specified relevant information. Importantly, parts of this register must be available for public inspection.
So greater transparency through digital means.
Exactly. Using technology to make crucial safety information more readily available to regulators, professionals, and the public. So, if we try and pull all these threads together, connect it back to that bigger picture, what we're really seeing with the Building Safety Act is not just tinkering around the edges, it's a fundamental redesign.
A restructuring of responsibility.
Yes, of responsibility, of oversight, of accountability right across the built environment, particularly, of course, for those higher risk buildings. The goal is to embed safety thinking right from the initial design stage, through construction, and throughout the entire occupation and management of a building.
And holding people accountable if they fail.
Definitely. Making sure those responsible are held to account. And I think it's worth noting, again, the specific inclusion of considering disabled persons' needs, both in resident engagement via the panels and in things like planning for emergency egress. It shows a more thoughtful and comprehensive approach to what safety actually means for everyone.
So reflecting on all this, what really stands out to you about how this act changes the game? Whether you're listening as a resident and owner, maybe someone working in construction or design, understanding these shifts is vital, isn't it?
It really is.
And it raises a big question for me, thinking about that long-term liability, especially the 30-year look back for some defects. How do you think that might genuinely change behavior in the industry? Will it push innovation and safety? Will it make investors more cautious? How will it shape decisions about quality versus cost going forward?
That's the multi-billion-pound question, isn't it? The long-term impact on industry culture and practice.
Absolutely. And maybe a final thought for everyone listening. We've seen this incredibly detailed regulatory framework with powerful enforcement tools and ways to make people pay for remediation. Beyond just deterring future mistakes, how might this act actively foster a proactive culture? A culture of genuinely seeking continuous improvement in safety, not just ticking compliance boxes across the entire life cycle of our buildings.